Good afternoon. Welcome to WG University, Weber Gallagher series of educational programs. This is our workers' compensation webinar series. I am Jennifer Labor, and I'm presenting today with Robert Hanneman and Renee Parada Frazier from our Philadelphia office. Renee works out of our Pittsburgh office, and Rob and I both work out of our Mount Laurel office. Each month, we present a current topic in workers' compensation legal issues. We present both case updates and ways to manage risk for your business. If you would like to view this webinar again, share it with others, or see our WG University programs, please visit the Weber Gallagher website at www.wglaw.com. And you will find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is Medicare Set Asides. Next month, our topic will be permanency and how to reduce exposure in a litigated Delaware permanency claim. Today, we're just going to talk to you not only about the Medicare set-asides, but we are also going to talk to you a little bit about conditional payment liens, just to give you a brief introduction as that as well. So now Rob's going to just give you a brief history about Medicare.
Why are we talking about Medicare? Medicare is a federally mandated medical program. It requires that Medicare's interest be considered with regards to any past medical bill repayment or possible future medical treatment exposure when related to workers' compensation cases as well as personal injury cases. The only party in the settlement process who really does no work in this is actually Medicare. All the parties involved in the litigation are the ones who are responsible for putting this all together on behalf of Medicare. The way this all came about was there was a law enacted back in 1980, Medicare Secondary Payer Act. It's a federally mandated law. Under that statute, Medicare will pay medical providers subject to later reimbursement from any third-party award, including settlements, judgments. Those also include workers' compensation judgments, personal injury settlements, and such. These are considered conditional payments. The Act also deals with issues of primacy for payment responsibilities. This is who pays first. Note that the Act specifically says Medicare is a secondary payer with regards to health insurance plans. That includes liability insurance, self-insured policies, as well as the Workers' Compensation Act. The law was changed for an act in 2012, which was enacted by President Obama in 2013. It's referred to as the SMART Act, called Strengthening Medicare and Repaying Taxpayers Act. It really didn't do anything. It was designed to explain what was going on, clarify, and give more strength to the Medicare Act as well as repayment efforts. Designed to enhance the Medicare Secondary Payer Act, it didn't have any great effect on anything that was going on. There was changes that was recommended, at least 6 of them. With regards to the enactment, the changes, the proposals, all the recommendations really didn't change anything that was going on or what we have been doing with regards to the Medicare. Now what? What happens when you have a case that involves Medicare? Jen's going to talk a little bit now about where we go from here.
So when a lot of times you'll hear us talk about a conditional payment lien or short CPL. What that is that Medicare requires under Section 111 reporting that if there's an accepted claim, you must, the carrier must notify Medicare that there's an individual that is under a workers' compensation claim that's Medicare eligible. And Section 111, there's the website that we have listed on this presentation that indicates to you the website is on Medicare's website, and it just lists exactly what's needed to be done with regard to Section 111 reporting. It's somewhat comprehensive, so if you're not sure, I suggest that you take a look at the website specifically. But for a conditional payment lien, you have to take into account whether or not this is an accepted or a denied claim. And if it's an accepted claim, you must do it. If it's a denied claim, the petitioner or the petitioner's attorney can technically contact Medicare because your Section 111 reporting guidelines are not something that go into effect if it's a denied claim. It's not something you actually have to do. But we all know many times right now, Medicare is not corresponding with either the petitioner or the petitioner's attorney. So it's important for you that you understand that many times it is still your responsibility, even in a denied claim, because prior to settlement, whether it be in New Jersey or in Pennsylvania, this is something that you must consider Medicare's interest and contact Medicare with regard to a conditional payment lien and potentially a Medicare set aside. Renee, in New Jersey, we know that we deal with an accepted case and a settlement, and there's two different types of settlements in New Jersey. We have an order approving settlement and a Section 20. Can you tell us a little bit about how, what specifically happens with the conditional payment aspect under those two issues?
Yes, this is actually a question that I get asked quite often from New Jersey claims handlers. The order approving settlement, because it does not actually close out future liability for medical, that is considered an event for Medicare. It still needs to be reported to Medicare as an event, changing what's going on in the case. However, that will not close out the Medicare conditional payment lien investigation. Medicare at this point should be issuing a current statement as to what they have located in terms of conditional payments. However, it will not be a final conditional payment lien. A Section 20, because that does close out future medical, when Medicare is alerted to a Section 20, at that point they will give you a final conditional payment lien statement. However, under the order approving settlement, because there is the potential that in the future medical could be foreclosed due to the exhaustion of the time for them to file a reopener, if that should occur, then that is also an event that the carrier should be reporting to Medicare. If the time period for them to file a reopener passes and they do not file a reopener such that medical is foreclosed into the future, then the claims handler should be reporting that, because at that point, it's my understanding that the medical would close.
Correct. And then you also have, if the claim is settled under an order approving settlement and it had been denied, obviously that the denial and the reporting requirements would then change when you settle under an order approving settlement. So your future responsibility for future medical treatment is that of the carriers up until the 2-year statute of limitations is expired. So the Section 111, if you're going to then go from a denied claim to an accepted claim, must happen at that point. Unlike with the Section 20 settlement.
Yes, that's correct. Once you have accepted liability for the claim, you must, pardon me, you must report it to Medicare.
And that would be, so most of the carriers, obviously, they either have someone in-house or they use a vendor that takes care of the reporting and handles these aspects for them.
Yes, the responsible reporting entity can be an in-house group, or it can be a separate entity that has the responsibility for reporting cases to Medicare.
Okay, and one of the things that I know, the reporting requirements now require that you appeal it within a certain period of time, any items that are listed on there. So it's important that when you get in the document that has items listed that Medicare thinks are related, that you check it or have whatever, whoever's handling the request, look through it and make sure that they challenge those things that are not accepted, because what could happen if they don't do that?
Well, if you do not meet the time requirements to make the challenge to the conditional payment lien, then you're going to be responsible for the lien. In addition to checking to see if the items that are listed are actually related to the accepted or adjudicated work injury, another element that I always ask clients to check is to see if perhaps we are looking at a duplicate payment whereby the carrier may have already paid for the treatment and it was billed both to the carrier and to Medicare, and so that you have both parties making payment. If it is something that has already been paid by the carrier, you would want to challenge it on that basis as well and provide Medicare with the documentation showing that the payment has already been made.
That's a good point.
It can become somewhat difficult to determine if you have a hospital bill where there are multiple elements to it. You would have to determine if in fact all of the elements that were paid by Medicare were also paid by you. It could be a situation where part of the bill was paid by the carrier and part was paid by Medicare, so you would really need to look very closely at the billing.
Okay. And in addition to the conditional payment liens, Rob, we have a lot of people aren't just on Medicare, but they're on these Medicare Advantage plans. can you just tell us a little bit about the Medicare Advantage plans?
Right. Well, one of the things we're talking about, for those who don't understand what we're talking about with regards to conditional payments, we're talking about medical services that have been provided to a petitioner, and there's been a bill submitted, and Medicare has paid that benefit, whatever the dollar figure is, for whatever services they were provided. In a workers' compensation case, if the petitioner has a low back injury and Medicare provided services for that low back injury, they're going to look for to recoup that money back with regards to whatever services they provided. One of the things that Medicare does not search is what's called the Medicare Advantage plan. This is a type of medical health plan that's offered by private companies that contracts with Medicare. Medicare Advantage plans provide all of your Part A and Part B benefits under Medicare. They include the HMOs and the PPOs, special needs plans, as well as the Medicare Medical Savings Account plan. There are private fee-for-services plans also. Most of these are also offered, most of these plans also offer a prescription drug plan. Why is this important? Because when there's a search done for conditional payments by Medicare, any benefits paid under your Medicare Advantage plan does not come up under that search. So there may have been benefits provided under your Medicare Advantage plan that don't come up under the conditional payment. You'll get a $0 conditional payment lien, but find out after the fact that there may have been benefits provided under the Medicare Advantage plan. The petitioner is part of the plan, so a separate request to the insurance company that covers the Medicare Advantage plan must be made in order to find out if they provided any benefits or services.
So Renee, exactly, I know you obviously do this. Renee is the firm's Medicare, the Medicare go-to. So Renee handles a lot of the Medicare set aside requests. She does this similar to how if you have someone in-house or a vendor, she's quite experienced in dealing with Medicare and the processes. But what do you recommend to clients when addressing whether someone's on Medicare, and specifically that aspect of conditional payment lien, which includes not only those items paid by Medicare specifically, but also the Medicare Advantage plans?
Well, I strongly recommend that when you are in litigation or just in negotiations, that you reach out to the petitioner through counsel if they're represented and inquire as to whether the person, one, has Medicare, and two, whether they have a Medicare Advantage plan. Oftentimes, you'll need to explain what a Medicare Advantage plan is because many people, when they receive that card, simply consider it all part of their Medicare plan. So what I typically do is I ask both for a copy of their Medicare card and a copy of any other health insurance cards that they may have so that I can determine if they have a Medicare Advantage plan. One issue I have discovered in dealing with Medicare Advantage plans is due to privacy concerns, they are reluctant to provide information to my office, both as the Medicare contact and also as defense counsel. I've actually had situations in which insurance companies have refused to even take the report of the workers' compensation injury on the basis that accepting the report would be acknowledging that the person has a plan through their company and that would be a violation of their privacy. What I often find is sometimes it's easier just to have the petitioner or petitioner's counsel to contact the company first. If they are willing to do so, then you can have them contact them. Oftentimes, the company will give them authorizations to be signed. You can have your name added to the authorizations. If petitioner and petitioner counsel feel uncomfortable contacting them because they may not be experienced in exactly what they need to do, what you can do is, and I've even set up conference calls where I'm on the phone with petitioner's counsel and we contact the insurance company jointly. We simply request authorizations to be sent to either my office or petitioner's counsel, depending upon who the insurance carrier is comfortable sending the authorizations to. We then fill them out, allowing for release of information both to myself and to petitioner's counsel, have petitioner sign the authorizations, and then we can submit them, request the documents. we would know specifically what to request. So typically I would submit them and provide copies, obviously, to petitioner and petitioner's counsel.
And this applies generally to all states, regardless of what the workers' compensation laws are. Whenever you're going to be settling a case, or whenever you have someone that's Medicare eligible, this is your responsibility under the federal guidelines, not state guidelines. So,
correct. Yes, this would apply to any state. You want to make sure if the person is Medicare eligible, if they have a Medicare Advantage plan.
okay. And one of the other flip parts of Medicare is the Medicare Set Aside.
Yes.
So we have Medicare Conditional Payment Lien, and then we also have the Medicare Set Aside. Now, the Medicare Set Aside in New Jersey and in any state, there's the review threshold. So what does that mean? So you must always, always, always consider Medicare's interest. It does not matter what the settlement is. You must always consider their interests. Now, there are a lot of claims that Medicare has to review, and because of the excessive amount of claims, Medicare periodically changes their review threshold. Currently, the review threshold, what?
Periodically.
Periodically, yeah. They haven't changed it in a little while, but periodically, they actually changed it several times in a few years. But currently, right now, it's if you are currently on Medicare, the review threshold is $25,000. What does that mean? That if a person is on Medicare, you can submit for formal approval from Medicare of your proposed MSA if your settlement is more than $25,000. If it's less than $25,000, they will not review it. They will not consider it. They will just send it back. Also, if you are not on Medicare currently, but you are going to be on Medicare in 30 months, which many times we know if a person's on Social Security disability and they've been approved for Social Security disability, they're going to be Medicare eligible within 30 months. You have the review threshold of $250,000. So that means that, again, they will only review those that if you're not currently Medicare eligible, but you're going to be within the next 30 months, you can only have a review of an MSA that's proposed for more than $250,000 when the settlement is that amount. And talking about the settlement, the review thresholds for the dollar figures, can you explain for both Pennsylvania and New Jersey about how Medicare comes up with those figures? What does it include?
Yes, the review thresholds do not include everything that has been or may be paid out on a workers' compensation claim. What Medicare reviews is what has been included in any past settlements and what is included in the current settlement. In New Jersey, you would look at prior orders approving settlement to see what was paid pursuant to those orders approving settlement. In Pennsylvania, you would look if there had been a prior indemnity only settlement and now you were closing out medical via a separate compromise and release agreement, you would include both of those amounts. But in New Jersey specifically, you would look at any prior orders approving settlement and the current Section 20 settlement to determine if the review threshold is met. Any amounts that were paid in your typical adjustment of the claim that were not part of a settlement would not be included.
And so that when we in New Jersey, so if we say the settlement is 15% of partial total and then there's a dollar figure, it's not just that dollar figure, it's whatever the respondent or the carrier is paying as part of that settlement. So if we're paying a portion of attorney fees, if we're paying a portion of expert reports, if you're paying for a fee of any type on that, if it's the insured or carrier's responsibility, that's part of that settlement figure, correct?
Yes, that's correct, because those are amounts that the petitioner would not have to pay so that it's a benefit to the petitioner, and that's what they look at.
Okay. And specifically with regard to New Jersey, when you're evaluating an MSA, can you go through the different types of MSA? I know we have a legal zero, a medical zero, and then when you're reviewing it and you're looking at a threshold that's over a certain amount, but you figure that there's going to be, clearly there's going to be future medical treatment related.
Yes, the legal zero would be those cases in which you are looking at a completely denied claim and there's a legal basis for the denial of the claim.
Okay.
Nothing has been accepted, no medical has been paid for. The Section 20 settlement would not provide for any payment of future medical. In those cases, you can present that to Medicare and ask for a $0 set aside. If reviews available, if reviews not available, you would simply want to document that you had this basis for allocating zero toward future medical for a Medicare set aside that's not Medicare approved.
Can I ask a question real quick? With regards, we keep talking about the threshold and whether or not you have to submit or you can submit a request to Medicare and things like that. There's no requirement that you have to submit the request to Medicare. There's just the threshold that you can submit over a certain dollar figure, correct?
That's correct. Okay. The way the law is written, it is not mandated that you submit to Medicare. However, we do consider it best practices that if Medicare review is available to you, that you do submit it to Medicare, because you will have more protections going forward if you have a Medicare approved set aside than if you do not.
All right. That leads into another question. What happens if you submit one to Medicare? Say you submit one for $35,000, Medicare responds and rejects your submission and says, we want $85,000. Is there a review process? Is there an appeal process? Is there a next step?
Yes, Medicare does have a very limited process by which you can request appeals. Some of the bases for the appeal is if Medicare did not properly interpret something. If you have something that's submitted to Medicare and the medical record specifically says this person does not require this treatment going forward, and Medicare included that treatment, you would then submit that documentation again to Medicare, say this was included in the original proposal. It should not have been included as future medical per this document. We are requesting that you remove it. You can also point out to Medicare if they've made a calculation error, if they have miscalculated the future cost of a medication or medical treatment. Those things happen. I'm sure all of us have miscalculated something. It does not happen that often in the Medicare set-asides, but there are cases where Medicare has simply miscalculated something. Medicare also has available a very limited review process for Medicare set-asides that have been approved if there is some sudden change in the person's treatment going forward. If the person has been receiving this medication for a number of years, it was included in the Medicare set-aside, something has now occurred where the medication is no longer effective, or the person may have developed another medical condition where the medication cannot be used, that documentation could be submitted to Medicare to adjust the Medicare set-aside. In that case, if a person's medication is simply changing and there is a large percentage difference in the change of medication, then you would want to submit it to Medicare. If it's simply the person was taking aspirin, now they're taking Tylenol, that would not necessarily be something that you would need to have Medicare approve a change on.
Now, Rob was talking about obviously a figure. In what situations does a figure normally come back, and what's the process that you do with regard to determining the Medicare set aside that would then be submitted either for formal approval or not?
Okay, what I would do in reviewing a Medicare set aside is I would look at the prior treatment that the person has received. Medicare looks at least the last 2 years of medical plus any significant treatment. If they've had surgery, if they've had implantation of a pain pump or spinal cord stimulator, those are things that you would want to include in the Medicare set aside. You would look at their past treatment, current treatment, any recommendations for treatment going forward from their treatment providers, and then extrapolate over their life expectancy what the projected cost is. That would include medications, any additional surgeries, diagnostic studies, routine office exams, and the like.
So in that you make certain assumptions with regards to how many tests they're going to have to undergo in the future, how many office visits, how much physical therapy, that kind of stuff, correct?
Well, what you do is certain testing is performed at certain intervals, and there are standard protocols for a person to undergo x-rays or MRIs at certain points throughout their life expectancy. So what you would do is you would say, okay, if this person is anticipated to need x-rays, x-rays typically occur every 5 years for a medical condition that is stable. Now, if the person's condition is in flux, if there's been a sudden change in their medical treatment or their condition, that may be a situation in which you want to delay proceeding with the Medicare set aside because you may not be able to determine what they're going to need going forward, or if they're going through a very large treatment protocol at present, it may be a situation in which you would want to wait and see how that protocol moves forward so that you aren't looking at an extremely high Medicare set aside because of that.
So an example may be if someone is having a spinal cord stimulator trial being recommended, and since obviously the review would be different if they actually have it implanted compared to if it doesn't work, the review would be different. So you would want to wait until that recommendation is approved, or if it actually is recommended, and then until the trial is concluded, correct?
Correct. With the spinal cord stimulator, you may also want to wait until the permanent implant is placed.
Okay.
We see often where individuals may have a much more positive response to the trial than to the actual implant.
Okay.
So that you may want to not only allow the trial to be completed, but also allow a period of time with the implant in place, as that can also give you an idea of how frequently the person may need to have adjustments made with the spinal cord stimulator. Some people are able to have the spinal cord stimulator implanted and only need adjustments every 6 to 12 months. Other people, because of their level of activity or other medical conditions, may need to have the implant adjusted more frequently. Until you have a few months in, you wouldn't know what level of frequency they would need for the adjustments. And you certainly want to be able to provide sufficient funding going forward over their life expectancy so that they could have the adjustments made at the frequency that they require.
Okay. And we also have medical zeros. So you have many of these cases, I think it's where it's a reopener, it was an admitted claim, authorized treatment, at some point they became Medicare eligible and they're come back, but many times we see where they come back and they ask for treatment, they go back to an authorized physician, and that doctor, who's not an IME doctor but a treating doctor, makes the determination that they need no further treatment and that they will not need further treatment in the future related to this claim. Can you explain a little bit more about a medical zero?
Yes, if you have documentation from a treatment provider that the person does not require additional treatment, that would allow you to have a $0 set aside. There's some question as to whether in those cases you would even want to submit it to Medicare. My personal opinion is if you have it and you feel confident that the doctor has explained why the person does not require any treatment going forward, then those are situations where you would want to submit that to Medicare. If the doctor maybe is not as clear, perhaps you would want to ask for some clarification before submitting that to Medicare so that Medicare can see that this is truly the doctor's opinion that the person does not require any additional medical treatment. If the treating doctor, and again, we're talking about a treatment provider, not an IME physician, if the treatment provider feels that it's not necessary that the person have any additional treatment, then that would be something that Medicare would rely upon in order to find a zero. One caution for that, however, I would place is if the person has a history of treating with multiple physicians, you may not want to rely solely upon a single physician to render that opinion. You may want to reach out to all of the person's treatment providers to determine that they all feel the same way.
Well, when you're making the submission to Medicare, you're supposed to be providing a certain number of years of medical records. So you would recommend reviewing that. And these are not just authorized providers, but it's any medical treatment for the related condition.
Correct.
And so a lot of times, especially if it's a reopener, it could be a unauthorized provider. And in those instances, it makes more sense to get a list of all the doctors. And it may not be an authorized doctor. It may be that the petitioner has to go and ask their doctor that they've been seeing. And the doctor can indicate that, no, this treatment is for some other reason.
Correct.
And that's something that we would recommend doing.
Yes, you would want to make sure that you have all of the medical records, even from non-authorized treatment providers, and that all of the records are consistent. You don't want a situation in which you're submitting something to Medicare based upon an authorized treatment provider's opinion that no treatment is necessary. Medicare then requests additional documentation, and you get the documentation from a non-authorized treatment provider that the person does need ongoing care, because then Medicare will look at that care as well.
And what do you recommend for Pennsylvania? Is it the same? Is it different?
Well, in Pennsylvania, we don't have authorized versus non-authorized care. In Pennsylvania, a person can treat with whomever they choose as their treatment provider. So in those cases, we don't have authorized treatment and then periods without treatment. We may have periods where the person is not treating.
Mm-hmm.
In those cases, what we would do if that person truly is not treating for the work injury, we would ask them for primary care physician records, or if the person treats through a Minute Clinic or a MedExpress type facility, we would ask them for authorizations for those types of clinic treatments so that we could get the records to establish that in fact they are not treating for the work injury.
That kind of leads me into another question. What's necessary from petitioner's counsel for you to complete an MSA?
First and foremost, we need their cooperation.
All right. Next question. No, go ahead.
What we would need from the petitioner is authorizations not only to obtain medical records from various providers, but also to communicate directly with Medicare. Medicare will not accept a settlement set-aside proposal and provide us with a response if claimant has not signed an authorization allowing communication, because again, these are claimant's records, not ours.
Understood.
So we need authorizations. Many times I find that the petitioner's attorney is in a much better position to obtain records than we are.
Mhm.
Oftentimes because if the person has been receiving unauthorized treatment, that treatment provider may not want to communicate directly with a third party or defense counsel, but they may be willing to provide the records in an expedited fashion directly to petitioner or to petitioner's counsel. So you really you need their cooperation.
And also, I know that one of the things Medicare usually likes is a certain number of years worth of prescriptions.
Yes.
So getting that, having them go to their pharmacy and getting, whether it be one pharmacy or multiple, but getting their printout of that, which it's easier, again, for the petitioner to get, correct?
Yes, exactly. Medicare typically looks back 2 years.
Okay.
So if you're dealing with a situation where, say, the person hasn't treated for 2 years, you would go back to the last date of treatment and get 2 years back from that.
Okay.
If the person truly has not treated anywhere for 2 years, what you would want to do is you would also want to go to their treatment providers and get a printout from the treatment provider listing all of their dates of service to show that they have not treated there in 2 years.
And I know Rob has a bunch of these occupational claims. How do you deal with those types of claims, or are there any recommendations? Because we see that these denied occupational, and if they're pled as one, it's one thing. If they're pled as multiple different claims, it's a different situation.
Yes, when we get these occupational claims that Rob so loves to send to me to do the Medicare set-asides, when you have a petitioner making a single claim against multiple defendants, or a single defendant but multiple carriers over a long period of time, one of the issues we run into is Medicare is going to look at the entire claim, not just our carrier's portion of it. So in those cases where you're trying to get Medicare approval, you need to get, again, cooperation from not only petitioner's counsel, but also from all of the other defendants and carriers involved in the case, because you will need to supply not only our carriers printouts of what has been paid, both for medical or for any wage loss. In those cases, it would be zero. Also, you would need a printout showing zero paid for medications. Medicare has also, over the course of the years, provided us with statements that we can have our clients as well as the other defendants complete, showing exactly that it's a completely denied claim, each of the injuries that are alleged, denied, nothing's been paid. And Medicare requires, when you're alleging that nothing has been paid, a lot of documentation. So when you're dealing with a single carrier, especially if it's your client, that's not hard to get. Once you're dealing with multiple carriers, many of whom are not your clients and many of whom you may be in an adverse situation with because you're arguing over who's responsible for the liability, it can be much more difficult to get the documentation. And each carrier has a different way of setting up their forms. So you may be getting from one carrier printouts showing 0, whereas other carriers are unable to give you a printout showing 0. And so you have to have them fill out these questionnaires from Medicare. And unfortunately, as Rob and I have discussed on many occasions, the specific language that needs to be used in these forms can vary depending upon who you're talking to at a certain moment in time with Medicare, such that it can take some time to get all of the documentation from the various carriers to Medicare.
Right, and I just want to go on the record saying that Renee has done a really great job with these kind of cases. She's actually created basically a form letter that when we have these kind of cases, she sends out to all the other defense counsels asking for the specific information as of right now that Medicare tells us that they want from all of the various defense counsels. We send it out right along with the authorizations that we send to petitioners counsel and a request for all the records, and we follow up as quickly as we can to get responses from them, because this is information we know Medicare is going to want. And if we don't send it in our initial documentation, they send us a form letter that says you have not provided us X, Y, and Z, and that just further delays the process.
Yes.
And if this is something, we could go on for hours about Medicare. So if you have any questions, you can contact, if it's a specific with regard to New Jersey, hopefully Rob or I could help, or you could also contact Renee, even if it's, Renee focuses on Pennsylvania workman's comp, but she does handle the workers' comp for New Jersey, the Medicare stuff for the entire office. So if you have any questions, feel free to reach out to any of us.
I just want to say thank you for all attending our webinar. Medicare Set Aside. Our next program will be the September 20th from the Philadelphia office, entitled An Update on Opioid-Related Laws and Policies. You can learn more about this program and all the Weber Gallagher events at www.wglaw.com/WG-University. Thank you for your time.
Thank you.
Thank you.